Mr Chair.
I call the member Jacinda Ardern.
Thank you, Mr Chair. It's my pleasure to give a contribution in the committee stages of this bill. Whilst I was a member of the Law and Order Select Committee who heard this bill, I wasn't unfortunately present for much of the either submissions or debate, but have read over the recommendations made by the Select Committee, which it'll be obvious to this House were brief, as it is a very brief but important bill, and important on two grounds, Mr Chair. First, obviously the timeliness of this and perhaps why it has been kept so succinct in the parts that we're debating, is that because it is important that we make sure these protections are in place in time for some of the important fixtures that we'll see in New Zealand. Based on 2008-2009 figures, we know it's a $5 billion revenue contribution to our economy, sporting fixtures and the like. So it is important that we make sure we have these protections in place, maintain our reputation, and maintain our reputation as being one of the least corrupt nations in the world as well. For the part that we're debating though today, Mr Chair, I think it's important to point out that what this bill does is insert within the Crimes Act the act of the fact that there will be able to be a crime under that act of deception, specifically obviously setting out well, even less specifically than before, that includes any omission that is done or omitted with an intent to influence a betting outcome of an activity of a kind to which subsection 2 applies, and then it makes reference to manipulating the overall result or activity or any event within the activity. Obviously, the Select Committee wanted to make sure there weren't unreasonable defences included in that clause, and I think it's right that the decision was made to allow that definition to be broadened out by removing what could be interpreted as a defence there, keeping out that wiggle room. But I want to reflect, though, to a couple of questions that are still left open as a result of the bill that we're debating here today, things that weren't included and perhaps could have been within the part that we're debating. Mr Mallard referred to the fact that sporting organisations, that there weren't many submissions, that individual codes weren't asked to submit, as I understand, and that raises for me the question as to whether or not those individual codes have plans on enforcement around this, these new protections that will be contained within the Crimes Act. How do we, for instance, oblige enforcement? How do we oblige monitoring? There's reference to codes of conduct. Do we know that every major code have these codes of conduct? Questions that you're only really able to intimately understand if they're individually submitting on the bill. So it's difficult to know whether or not actually this part that we're debating could or should have gone further in terms of obliging codes to ensure that this new offence within the Crimes Act is not being committed, because you know what you know, and sometimes you only know when you go looking. We have been told, of course, that the Department of Internal Affairs, Sports New Zealand, the New Zealand Racing Board, the Ministry of Justice, the Organised Financial Crime Agency New Zealand and the Serious Fraud Office have agreed to collaborate to try and address match fixing. But again, collaboration is one thing, being well resourced to undertake that work is another. We already know, for instance, that the Serious Fraud Office is a seriously under-resourced organisation. They've even made budget bids to this government to allow them to do preventative work around potential corruption and financial crime off the back of the massive rebuild following the earthquakes in Christchurch. And we know that they were denied that additional support. We know that they're prosecuting fewer cases and that the threshold for prosecution has really been raised in practice. So yes, great collaboration between those organisations is necessary, but hard to know how much proactive enforcement will be undertaken. So I question whether or not we're actually missing some of what should have been included around this part. Also, there is some discussion, I've heard some discussion over the fact that individual codes have rules that allow them to, for instance, the Racing Board, to cancel sports bet if they considers that they may be at risk of corrupt betting. Now, are there areas and other codes where we should have been making sure, Mr Chair, that, Mr Chair,
Jacinda Ardern.
that those kinds of provisions may have been necessary in other codes. A racing board obviously have a number of reasons why they would want to make sure that their sport is squeaky clean and that they're not falling foul of any best practice. But do we know for sure that other codes have similar rules in place, specifically around the way that their betting is conducted and applied? So creating the offence that we're debating here is one thing, but as we all know as parliamentarians, simply setting a new set of rules and guidelines is actually only the first step. Enforcement and monitoring is just as important as having the redress in legislation when things do go wrong. And we can see the damage that is done if you allow a sporting code to get to a point where they're having to use the arm of the strength of the law in order to uphold standards, and we know how damaging that can then therefore be to that code. So that's one of my, those are two of the major points that I wish to raise for this part of the debate. Are we missing both a step when it comes to ensuring decent enforcement, and I encourage the Minister, if I've missed that, if there's some other work that's gone on behind the scenes, additional codes that have been, codes of conduct that have been established, I would be interested to hear that, because as Mr Mallard pointed out, I think we missed an opportunity by the fact that some of those codes were not asked to submit and therefore did not submit at Select Committee. So we only know what we know in that regard. And also whether or not the coverage therefore is what is going to meet Parliament's expectation. So those would be the issues that I wouldn't mind the Minister and the Chair perhaps addressing. If he could also speak to the nature of the collaboration that apparently is going to happen between the Department of Internal Affairs, Sports New Zealand, the New Zealand Racing Board, the Ministry of Justice, Organised and Financial Crime Agency and the Serious Fraud Office. Is there any particular one of those agencies which is the lead agency that will take the key responsible role? Have they had additional support in taking that role in terms of resourcing to make sure that they take preventative action around match fixing? And the Serious Fraud Office, have they, for instance, raised any concerns about their ability to be involved at the degree to which the government may expect them to be, given we have seen a considerable change in their resourcing in recent times? So those are all of the things I wouldn't mind hearing from the Chair and which I would be interested in responding to in another part of the debate, dependent on how adequate the answers to those questions may be.